We're just going to give it a few minutes and let some more attendees join. A couple minutes till we need to start.
This is exciting. Sarah, do you have any predictions about which circuit court is going to get? They all have an equal chance, right?
That's right. So what is it? 1 in 11?
Yeah, I think all the circuits are involved. So yeah.
Oh, the 10th
12.
finally got in?
12. Yes.
I didn't.
Yeah, the 10th circuit is in. So that's it's a 1 in 12 chance. Just
Wow.
I think yesterday, the
Oh, I hadn't seen that.
Newspaper Union Writers Guild from Denver, I think. So Union from Denver filed an appeal or a challenge, I guess.
I hadn't seen that. So a 1 in 12 shot. I'm not a gambler, so I wouldn't even know what the odds are. I guess 1
Well,
in
and it's
12.
not weighted or anything like that. So
it is noon, but I think we're just going to wait probably like 2 more minutes, let people join.
yeah, I think that's fine. Let people jump
Perfect.
on.
Yeah, of course. Don't want to miss this today. Jim, Sarah, are you guys okay if I get started?
Yep,
Okay,
ready to go.
perfect.
Fine.
So thank you. Oh, thank you everybody for joining on today. I'm Megan, I'm with the Ohio Chamber. We're really appreciative of you guys coming along, hopefully for this incredible webinar. I have really good expectations for this. Just so you know, we will send out this presentation either today or tomorrow, along with contact information for Jim and Sarah. But Jim Yates and Sarah Palicki are members of the Labor and Employment Group of Eastman and Smith and are both SHRM Senior Certified Professionals. Combined, they have over 40 years experience representing employers in labor and employment matters. They partner with business leaders and human resource professionals to develop and implement practical and legally compliant employment policies and assist employers in assessing and minimizing legal risks. Excuse me. They represent public and private sector employers in various labor and employment law matters. Oh, that is my phone. I apologize. Including collective bargaining, general personal practices, equal employment opportunity matters, wage and hour matters, workers' compensation, and workplace safety matters, and compliance with numerous state and federal laws and regulations affecting the workplace. And again, I will be sharing out their contact information, as well as this presentation either today or tomorrow. So I'm going to pass it on to them and they will get started.
Thanks, Megan. Thanks to the Ohio Chamber for sponsoring this. So the pressure is on, Sarah. The expectations are high, according to Megan. So this is such a hot topic today, of all days, too. We might actually, there might actually be some movement going on, during, Sarah and I are both monitoring our emails and the internet and trying to see if there's going to be this lottery. But let's back up a little bit. So we're going to be talking about OSHA's emergency temporary standard. So we'll just call it the ETS. Again, things are changing so fast with the ETS. And so we'll tell you what we know about the ETS, as of noon today. That may change within the next couple hours, depending on how things shake out with some of these legal challenges. But so we'll spend the next hour or so answering questions, drilling into the details of the ETS. And initially, I'll talk a little bit about the legal challenges because that is sort of the elephant in the room right now. We're all sort of waiting to see what happens with one of them. But I think let's back up a little bit and talk about what exactly an ETS is. So we never really spoke about ETSs that much. Lawyers didn't, and this is sort of a new term that everyone is now trying to work through. So an ETS is just an emergency temporary standard, and it's issued by OSHA, but because it's an emergency rule, OSHA is permitted to issue the rule immediately without the typical notice and comment period that we would expect from an OSHA regulation. So because it's an emergency rule and because OSHA is bypassing the typical notice and comment period, OSHA can only issue this rule if it determines that workers are in, quote, grave danger. So we're hearing a lot about that term, grave danger, and particularly some of the legal challenges. And it's supposed to be grave danger due to an exposure to toxic substances, agents determined to be toxic or harmful, or new hazards, and that an emergency standard is needed to protect workers. So that is the legal basis for what OSHA needs to show to promulgate and enforce an ETS. And so this is where the legal challenges are sort of taking aim at. Because it's an emergency rule, it's only in effect for 6 months. But during that 6 months, the normal notice and comment period takes place. So you have the ETS out there, and right now for the next 6 months, stakeholders are able to issue comments and write in, and OSHA is supposed to consider those, and there may be some hearings on this. as would happen if it was a normal non-emergency rulemaking. And at the end of that 6 months, you're supposed to have really a permanent rule after stakeholders have a shot at giving some input into this new rule. Or the rule could just be pulled after 6 months if there is no emergency. So, but that is the process. Importantly, as we found out, an ETS may be challenged in an appropriate U.S. Court of Appeals. So this is what we call a circuit court, a federal court of appeals. And in fact, it was challenged before it was even issued. And then once it was issued, there was a flood of litigation. And as it turns out, it was challenged in every court of appeals. So now we're faced with today, well, let's back up. We'll wait a little bit. So by the time I get to that slide, maybe we'll figure out what Court of Appeals is going to be handling this. So let's go to the next slide and run through a little bit more of the background of the ETS. So I was jumping the gun a little bit on that. So the purpose of the ETS is to strongly encourage vaccination for employees of employers with 100 or more employees. So really what OSHA is doing is trying to get employers to encourage or force employees to become vaccinated. It's the Biden administration's position is that that they want employees to be vaccinated. That is, in their view, the best way to get to the other side of this pandemic. So the ETS is designed with that purpose in mind. So when we talk about the requirements of the ETS, you need to remember that is the stated purpose of the ETS is to strongly encourage vaccination. So everything is sort of aimed at that purpose, not necessarily testing. I mean, OSHA doesn't want to encourage testing. They want employers to mandate vaccines where, if at all possible, and encourage employers to mandate vaccines. So it establishes minimum vaccination verification requirements, face covering and testing requirements. As we'll see, those that are unvaccinated are going to have masking and testing requirements. It's also the stated purpose, as I indicated, it has to be, if it's an emergency temporary standard, to address the grave danger of COVID in the workplace. And one of OSHA's stated purposes in the ETS is that OSHA specifically wanted to preempt any inconsistent state and local requirements, particularly requirements that would ban the ability of employers or even the federal government to impose vaccine mandates. So in Ohio, we have some legislation that is proposed out there that would do just that, to prohibit employers from firing employees if those employers don't agree to a vaccine mandate. Importantly, also, the ETS does not supersede collective bargaining agreements or any other agreement that might provide greater protections for employees. And just last week, the National Labor Relations Board General Counsel came out with a memo reiterating unionized employers' obligations to engage in collective bargaining over specific terms contained in the ETS. In other words, the NLRB General Counsel believes that employers do have bargaining obligations with their union over items that are contained in the ETS. So employers that are signatories to union contracts really need to focus in on that and remember that as they're, rushing through trying to prepare for the ETS and preparing policies. The union has to be at least in the loop on those, and there's some mandatory bargaining obligations with respect to some of those issues. So again, covered employers under the ETS must develop, implement, and enforce mandatory vaccination policies, or follow some very specific requirements for weekly testing and masking requirements for unvaccinated employees. Some important dates to remember: the date that it was published in the Federal Register was November 5th, but the compliance date for some of these policy issues that we'll be discussing is December 6th, 2021, and the compliance date for testing and vaccination is January 4th, 2022. So that was one of the concerns from whether it's from various business groups were lobbying for a date that it would at least get us beyond the holidays, particularly, for retailers, right? Or anyone in that space, so that at least there wouldn't be vaccine mandates starting until after the holidays. Now, if you have your second dose, so you get your second vaccination shot by January 4th, you don't have to wait the 2 additional weeks, which would normally make you fully vaccinated. You'd basically just get out of a week or 2 of testing on, January 4th if you have your second shot by then. But so, as you can see with these deadlines, if you need to get if employees need to get vaccinated, they need to really start that vaccination process in the beginning of December, and employers have these compliance deadlines on December 6th. So these are key dates to keep in mind. And also remember, if there's federal employee vaccine mandates, so federal employees actually have to be vaccinated by November 22nd. So we're seeing a lot of stories about how many federal employees are still unvaccinated, and that November 22nd date is looking a little bit problematic in terms of, maybe there maybe some federal employees, won't be able to work that day. And for federal contractors and subcontractors of federal contractors, that deadline has now been extended to the same January 4th deadline that we're dealing with under the ETS. So the private employers plus federal contractors, federal subcontractors, if they're under the federal contractor requirements, would similarly have, the subs and federal contractors would similarly have to be mandated, or would be mandated to be vaccinated by January 4th. And for the private sector employers with 100 or more employees, those employees would either have to be vaccinated by then or subject to the testing and masking requirements of the ETS by then. Okay. So here we have the legal challenges. The ETS has been challenged in every single federal court of appeals now. So the Fifth Circuit had been challenged in the Fifth Circuit Court of Appeals, which is known as the most conservative judicial court of appeals really in the country. And the Fifth Circuit issued November 5th, issued a decision imposing a stay with really not much of an opinion behind it. Just, look, we're going to take a look at this. We're going to fight. You guys are going to file briefs, but right now we're issuing a stay because of the what they called grave statutory and constitutional issues involved. Just last Friday, that same Circuit Court of Appeals, so it's the 3-judge panel within the Fifth Circuit, issued I guess what I would call a stinging rebuke of the base of OSHA's basis for issuing the ETS in the first place. And that is probably putting it mildly. So in a 22-page opinion, the court extended that stay and ordered OSHA to what they said was take no steps to implement or enforce the mandate until further court order. So this is the Fifth Judicial Circuit. It covers Louisiana, Mississippi, and Texas. They decided a number of consolidated cases, and those cases were filed by businesses, by individuals, by religious organizations, and by various states. So the Fifth Circuit, very interesting decision, had no problems issuing the stay, and so that so going forward, that's the opinion that we have out there. It indicated that the ETS was both over-inclusive because it didn't really even contemplate employees working for different industries and different locations and different areas. And it was also under-inclusive because if there's a grave danger to workplaces, how do you distinguish between a workplace that might be really crowded and people working in close quarters that have 99 employees, but yet another workplace that the ETS applies to might be spread out all over the country and not have the same working conditions at all. So that court issued again a pretty stinging rebuke of the ETS. Now, what happens now? Well, interestingly, now I indicated that these challenges have been filed in every single court of appeals throughout the country. So we have 12 of them pending now. So believe it or not, what court ultimately decides this issue might ultimately be the U.S. Supreme Court, but what Court of Appeals decides this issue is not based on who filed first and what court. They just literally put the names of the court in a drum and mix them up, and one person picks out a name, and somebody, an impartial observer, witnesses it, and whatever court's name gets picked out, a 3-judge panel from that Court of Appeals will actually decide all of the appeals from all of the circuits. Will get consolidated into this one Court of Appeals. So the Fifth Circuit still has a shot at it, and we kind of know how we think it would come out in the Fifth Circuit, given their lengthy decision issued Friday. But it would be a different panel of judges, and so it really matters what court is assigned to decide the issue, and what judges from that particular Court of Appeals are put on the panel. So, pretty interesting that such an important issue can be decided by sort of the luck of the draw. So we're all, right now monitoring to see, what court is picked in the lottery. I will tell you that there's, out of the 12 courts, there are 4 courts with democratically appointed, judges. The majority of the court is democratically appointed judges. 6 of them with, judges that were appointed by Republican presidents, and then 2 of them that have a split with Democratic appointments and Democrat appointments and Republican appointments. So really, really interesting from a legal standpoint. We don't see this all that often, but that lottery is today. That's why we're so excited about it. And ultimately, it could have a big impact on whether or not the ETS is upheld, which could go either way, depending on where your organization is on whether you want the ETS to be upheld or not. So now moving on to, I guess, some more mundane issues, which would be the actual substance of the ETS. It would apply to all employers with a total of 100 or more employees at any time the ETS is in effect. So as of November 5th, if you had 100, the ETS is going to apply to you. If November 6th, you have November 6th, you had 100, November 7th, you go down to 99, it doesn't matter. You still have 100. So you can't just lay off some employees and say that the ETS doesn't apply to you. So, so a total of 100 employees at all of your US locations. So it's not, doesn't go by the specific location, it's all total. So you could have, 20 employees at 5 locations and you're covered. Okay. So 2 or more related entities could be combined. So if you have a couple related entities that, might be, we have to look at factors like, okay, do they have their own, are they a separate legal entity? And where are these decisions regarding HR, workplace safety, those things? Are they made company, are they made for both entities, or are they separate HR departments, separate workplace safety departments? OSHA could try to combine some of those. They call it the integrated employer test. So we have to be careful with multi-employer worksite locations. I think construction companies breathe a little bit of a sigh of relief on this, because if you have a multi-employer construction site with, hundreds of employees, I think some general contractors and some smaller contractors were concerned that that work site is well over 100 employees. And if they go by work site, everyone at the site is covered by the ETS. Well, OSHA said that that's not the case. We go by the number of employees that the contractor or subcontractor or materialman has, not the total number on the site. So small contractor, 20 employees, just because they're working on a work site that has hundreds, if not thousands of employees, doesn't mean that they're automatically covered by the ETS. As far as temporary companies and customers of temporary companies, those are separate as well. So if you have a temporary company that is supplying, 20 employees to a customer, and the customer has 120 employees without the temps, then the temporary company isn't necessarily covered just because there's over 100 employees at that workplace. But they are if they have more than 100 employees at any workplace. So this can get a little bit tricky. Conversely, if a temporary company is supplying 30 employees to a customer that has 80 employees, neither of them are necessarily required, and that employer isn't required just because the 30 temps add up to over 100. Obviously, the workplaces that are covered under the federal contractor guidance and the federal contractor executive order, those workplaces are not covered also by the ETS, and workplaces that are covered under the current healthcare ETS are not covered either, because they're already covered under emergency temporary standard. That is far more stringent actually than this one. So some employees aren't covered, and those employees are ones that don't report to a workplace where other workers are. Okay, so they might report to a workplace, but it's after hours, no other workers are present, customers aren't present, or doesn't apply to employees that exclusively work from home or exclusively work outdoors. Now, OSHA is going to construe those exemptions very narrowly. They say that, they think that even only 10% of construction or landscape technicians would exclusively work outdoors, and that those would be the two professions really that would have most of the exclusive outdoor workers. Couple of things that the ETS does not require. We thought that maybe, given OSHA's prior guidance and the healthcare ETS, that OSHA would require employers to provide policies that would include maybe physical barriers or analysis of physical barriers, social distancing, disinfecting workplaces. We've heard a lot about, how important ventilation is with the spread of COVID. So we thought that maybe the ETS would require, certain HEPA filters or HVAC or ventilation requirements. It doesn't do any of that. It only deals with that mandatory vaccination or testing and face coverings for the unvaccinated. It only deals with employers with 100 or more employees, doesn't cover employers with fewer employees yet. OSHA says that they're looking at that issue, so they want comments from interested parties about perhaps taking that number down. So if employers thought that they were at 99 on November 5th, so they got out of this, well, that celebration may be short-lived if, in fact, by the time a permanent standard, if one is viable at that period of time, it might be down to 50 or 20. Who knows? So those employers need to pay attention to these requirements too. It doesn't require pay. The ETS itself doesn't require pay for these tests or testing. Remember, if the goal is to have employers mandate vaccines for employees, then really employers should be making it more difficult for employees to go with the testing option, which the ETS basically does. Employers don't have to pay for tests or testing, but they, as you'll see, they do have to pay for time related to getting vaccinated. So there's this very specific policy considerations about encouraging employers and employees to be vaccinated.
Okay, so Jim covered the purpose of the ETS and what is not included in the ETS. And, we had been hearing about and waiting for the ETS for so long. There were a lot of pundits out there saying, we think this is going to have XYZ in it. So there were some surprising things in the ETS that we hadn't anticipated, and other things that were left out that we thought would be in there. But what does the ETS require? It requires every employer to have, with 100 or more employees, every covered employer, to have a policy on vaccination. And the primary policy that OSHA wants each employer to have is a mandatory vaccination policy. So that is what the stated purpose of the ETS is, and that is OSHA coming out and saying, we want each employer to have a mandatory vaccination policy. Now, they did concede in the ETS that it might be, in certain circumstances, appropriate to have a policy that does not require mandatory vaccinations, but only if you have a policy that establishes, implements, and enforces a mandatory vaccination policy for all of your employees to be fully vaccinated, or they provide proof of regular testing for COVID and wear a face covering. So all of your employees must be vaccinated. And in the event that the employee is not vaccinated for whatever reason, they must provide proof of regular testing and wear a face covering. So the first thing employers have to do is determine in their workplace who is vaccinated and who is unvaccinated. There are some pretty specific requirements on how you determine what is proof of vaccination. We must determine whether the person is fully vaccinated. That means you need to know the dates of each vaccination. And you must get acceptable proof of vaccination status, including whether someone is fully or partially vaccinated. So once they get that first shot, they should be informing you that they are partially vaccinated. Acceptable proof of vaccination is anything from a pharmacy, a copy of the card, a copy of a medical record documenting the vaccination, copy of immunization records from the local health department or whatever government entity had the vaccination record, any other copy of official documentation. And in the very unlikely event that someone is unable to produce proof of any of that, which frankly should be pretty unlikely, because if you've lost your vaccination card, there are ways for you to go ahead and get that proof. But in the event that someone has no proof of vaccination, they must provide an attestation of their vaccination status, whether they are fully vaccinated or partially vaccinated, attesting that they have lost or are otherwise unable to produce proof required for compliance with the ETS. And it must also include the following language: I declare or certify, verify, or state that this information about my vaccination status is true and accurate. I understand that knowingly providing false information regarding my vaccination status on this form may subject me to criminal penalties. And that language must be on the attestation. So OSHA is taking it very seriously that people need to be providing proof of vaccination and warning people that if they're making this up, they could be subject to criminal penalties. So this isn't the typical employment form that we put in front of our employees. Typically, we put in, a document in front of an employee that says, I understand I've received a copy of this policy, and that if I don't comply with this policy, I could be terminated. This specifically requires employers to say that they will be subject to criminal penalties under the ETS. So little different. And as Jim pointed out, the goal here is to get people vaccinated. So we're going to threaten them with criminal penalties if they're lying about their vaccination status. There were also some surprising things in the ETS, at least it was surprising to me. We have been dealing with vaccine questions for a while and what the possible exceptions are to vaccination. And traditionally, we talk about the exceptions being an individual with a disability under the ADA or a sincerely held religious belief. OSHA's ETS actually goes a little bit broader than that and says that there are 3 vaccine exceptions. The first are for those whom a vaccine is medically contraindicated. The second, for whom medical necessity requires a delay in vaccination. Or the third, where federal civil rights laws, Title VII, the ADA, protect individuals because they have a disability or a sincerely held religious belief, practice, or observance that conflicts with the vaccine requirement. So it's more than just a disability. It's anyone for whom a vaccine is medically contraindicated, not an individual. The person might not have a disability that needs accommodation, but if their doctor provides them with proof that the vaccine is medically contraindicated for this person, that is acceptable. Or this person may be able to have a vaccine, but right now they're not able to have it. And so that comes up. I've been seeing it a lot in women who are trying to conceive, and their doctor says now is not the right time for vaccination, but later down the road, when you're no longer trying to conceive, you can be vaccinated at that time. So these are different exceptions that we haven't been dealing with and that we're learning about now. And those are probably things that you're going to be hearing about in your workplace as well. So what does it mean for an individual with a disability? Under the ADA, employers are required to provide employees with an available accommodation as long as it doesn't pose an undue hardship, meaning significant difficulty or expense. And you have to engage in the interactive process to determine the appropriate accommodation. We've been dealing with the ADA for a while now. We're used to that. And so possible accommodations for an individual with a disability are weekly testing, wearing masks, socially distanced, working from home, having remote workers, or if none of that works for the individual, an unpaid leave of absence. And that has been found to be an acceptable form of an accommodation. What we don't deal with quite as frequently is the sincerely held religious belief. Most of the time in our workplace, we don't have to go out of the way to provide religious accommodations for individuals. It comes up every now and again when there is a religious holiday and we're scheduled to work on that day, et cetera. But it doesn't really come up all that often. So a lot of people are just now learning about what it means to have a sincerely held religious belief. So the first thing that I always tell employers is we should generally assume that a request for a religious accommodation is based on a sincerely held religious belief. We don't want to get into the questioning of whether or not this is a real religion or questioning the veracity of the individual sincerely held religious belief. However, if you do have an objective basis for doubting this individual's sincerely held religious belief or doubting the religious nature of the belief, then you are permitted to make a limited factual inquiry regarding whether or not the individual has a sincerely held religious belief. If someone fails to cooperate in the process of determining the veracity of their sincerely held religious belief, then you can deny the request for accommodation if there's no participation. And that is included on the disability side as well. So what we need to remember, however, is that Title VII protects all religions, even those that we don't understand, that are new to us, that are non-traditional, and that we've never heard of before. In that case, you may ask the individual to provide additional information to help you understand and to explain the religious nature of the belief, because they are quick to point out that Title VII does not protect social, political, or economic views or personal preferences. It needs to be a sincerely held religious belief. Once you receive that information from the employee, though, some kind of statement that it is a sincerely held religious belief, you need to accept that and not question it further. And I've had clients ask me, well, I want to get a note from the person's pastor or their spiritual advisor. That's okay. They can provide that to you if they have that. I am suggesting, however, that you don't require they provide that, because a sincerely held religious belief does not require that someone has a spiritual advisor. It doesn't require us to go to a church with a pastor. It could be the Church of Sarah Palicki. I have a sincerely held religious belief that I cannot be vaccinated. This is my sincerely held religious belief. I have never gotten any form of vaccination. I have never gotten a flu shot. I've never gotten any kind of shot. And if I put that all down in paper and explain the basis for my sincerely held religious belief, that is enough documentation for that individual to be entitled to an exemption. It's a strange area that we don't deal with very often, but be very cautious when questioning those sincerely held religious beliefs.
So we indicated that the base, one of the purposes, express purposes of the ETS is to have employers encourage, strong arm, force employees to become vaccinated. And by the way, this is the perfect opportunity if you're an employer that wanted a mandatory vaccination policy for your workplace. Now's the time. Go ahead and get that in place. You have, this ETS that's been issued, and it hasn't really been overturned by anyone other than the Court of Appeals, and it's gonna get assigned to another court. So if you are out there and you don't really want to have that type of a policy, you might want to hold tight for a little while and see how some of these legal issues shake out, while at the same time preparing for for this to be implemented on December 6th. So you don't have too much time to wait. But so the employer must support vaccination through some very, very unusual provisions in the ETS. So this is something types of things we haven't dealt with before. As Sarah indicated, some of these other issues on the accommodation, we've dealt with some of those, but some are also very unusual. So this is paid time off is required for employees under the ETS, so that an employee can go and get vaccinated. So the paid time off is 4 hours paid for each shot. So it's 8 hours, and that's over and above any paid sick time that the employee might have on the book. So it's a additional benefit for employees, and that's to go and travel and go and get the shot or shots. And also, employers also need to provide paid time off for recovery if there's any side effects for getting the vaccine. So, and that time is 2 days paid per dose, but that time you can require the employee to use some paid time off if they have accrued unused paid time off. But if they don't, you have to pay for that time. So it's 4 hours each shot, and then recovery 2 days for each shot. That's got to be paid somehow. So what about individuals that, what if we're not doing a mandatory vaccination policy, individuals that aren't fully vaccinated? Well, the employer and the employees have to jump through a number of hoops contained in the ETS. So this is, if you're not fully vaccinated, then you as an employee has to get tested once every 7 days. So before you can actually work. So it's mandatory testing, and that's every 7 days, and you have to provide documentation of that testing to your employer before you can come back to work. If somebody doesn't regularly work at the employer's workplace, or maybe they've been gone for a while, maybe they've been working remotely for the last 2 months, those employees have to provide the results of their testing within 7 days of their return to the workplace. So, and as we'll see, there's certain requirements of what tests you have to take, how those are administered, how they're documented, how you have to retain the record. So Sarah's going to walk you through those, a couple of those items.
So because we have this testing requirement, everybody wants to know what it means to have a test. So OSHA is very clear that the approved tests are only those that are FDA approved to detect current infection. And so that's an antigen test. Antibody tests show evidence of prior infection, but that doesn't show evidence of current infection. So we need to have an antigen test that is designed to show whether or not there's active infection. The test must be administered in accordance with the instructions, and it can't be both self-administered and self-read unless the employer or an authorized telehealth practitioner observes it as well. So that means if you have your employees provide their own FDA-approved tests, they can't administer them at home and bring the test result to you unless it was observed by a telehealth practitioner. They could also go to a pharmacy or something like that. It has to be observed by someone else. They can bring it to you as the employer and do it in front of you, and then you may observe that testing. So I had lots of questions about that, meaning, people saying, oh, does that mean we need to have a healthcare provider on site? No, these may be self-administered, but you as the employer need to observe it. So you could have a supervisor, your plant manager, whoever, just sit in the room and watch these test results or have the tests administered by the employee. That way we have proof that the test result is what it is when it comes, out and is completed, okay? So it must, if it's self-administered, it can't be self-read unless it's observed by you or a telehealth practitioner.
So what happens if you don't provide your test results as required under the ETS? This is the you're out slide. So that you have to be removed from the workplace until you comply, until you provide that test. And this we thought was a little bit interesting in that if someone actually has been diagnosed with COVID or has a positive test, then that employee cannot be required to go through the testing process because OSHA says there's too big of a risk of a false positive. So that person is sort of, I guess, exempt from the testing requirements for a 90-day period. The tests must be maintained as a confidential medical record under OSHA's rules that deal with exposure to hazardous substances in the workplace. So they're considered confidential medical records. So employers need to have safeguards built in to their policies and also training that to make sure that you're not broadcasting these test results and putting it on a platform that's available to everyone, or heaven forbid, posting this type of information. We'll get into this when we talk about rosters of vaccinated and unvaccinated too, because they are confidential medical. It is confidential medical information and it has to be retained as such. We're used to retaining confidential medical information under the Americans with Disabilities Act, and we limit the amount of the numbers of people, and we only have people that really need to know that information have access to that. So you're going to retain this information as confidential medical records.
In addition to weekly testing, all unvaccinated individuals must wear a face covering. And over the last year or so, we've all been trying to figure out what a face covering means. And now this ETS specifically defines and puts requirements on a face covering. A face covering must completely cover the nose and mouth. It can't be worn under the chin or off the ear. It must be worn over the nose and mouth. It must be made of 2 or more layers of fabric that tightly woven so that light cannot pass through. The only time you can have a face covering that allows light to pass through it is if you have one of those special clear masks that are used for individuals with hearing difficulties. So other than that, it must be 2 layers of fabric that light can't pass through. It needs to be worn securely to the head. And if a gaiter is worn, it has to be doubled up or it has to be 2 layers. So what we learned from this ETS is that a face shield, those clear plastic shields that people were wearing, do not constitute a face covering. A face covering has to cover the nose and mouth and be tightly worn over the face. So you may wear a face shield in addition to a face covering, but not in instead of a face covering. It must be a solid piece of material without slits or valves or holes, no fishnet face coverings, and again, no face shields. You must require that all of your unvaccinated employees wear a face covering at all times when they are indoors or in a vehicle with another person for work purposes. The only time an individual who is unvaccinated may not wear a mask is if they are in a room alone with floor to ceiling walls and a closed door. So this is different than what we perhaps had been thinking prior to the issuance of the ETS. This specifically says they have to be alone in a room with walls all the way to the ceiling and a closed door, unless they are eating or drinking for a very limited purpose or period of time, or for identification purposes, say at the security desk, if you need to see the person's face, they may lower the mask at that point in time. Or if they are wearing a respirator or face mask, and Jim will talk about that. And we do still have the exception if it is infeasible or causes a greater hazard for the individual to wear a face covering. If it is extremely hot in the workplace and wearing a face covering would be difficult to breathe, then OSHA has recognized the greater hazard exemption for wearing the face covering. Jim, did you want to pipe up and say anything about respirators or face masks?
I think that's in the next slide.
Nope. This one right here.
Okay, so if the employer actually provides respirators, then the employer has to comply with what we call the mini respirator rule, and that's in the healthcare ETS. So folks that are used to some of those healthcare regulations, typically if an employer supplies, mandates a use of a N95, that's a respirator, and that would trigger a respirator protection program, a respiratory protection program for the employer. But if you're providing these N95s, you just, for your employees, you can comply with the mini respirator program, which means that you don't have to do a fit test, you don't have to do a medical examination, and you only have to do a seal test and provide some training on wearing and use of the N95s.
An employer must make sure that any face covering is worn to cover the employee's nose and mouth and must be replaced when wet, soiled, or damaged. And you may not prevent any employee from voluntarily wearing a face covering or face mask unless the employer once again can show that it would create a serious hazard or injury or death. Again, the greater hazard exemption. So a lot of times we've been hearing about individuals that have been saying, we're going to have two classes of people. We're going to have a group of people that are wearing masks and a group of unvaccinated people that are wearing masks, and then the vaccinated people don't have to wear the masks. Well, that might be the case. However, you may not prevent your vaccinated employees from wearing a mask. So just because someone is wearing a mask doesn't really determine their vaccination status. The one tricky part about that is for employers, though, is that you must enforce the face covering requirement for your unvaccinated individuals. So if you have two individuals in a room, both wearing face coverings, and one of them takes it off, you have to determine which one is unvaccinated and needs to be told to put it back on, as opposed to the individual who is fully vaccinated and has no requirement to wear the mask in the first place. It's a little bit counterintuitive, but that is what OSHA is telling us we need to do. You may also not prevent visitors and customers from wearing face masks. So it's important to update your policies and allow your visitors and customers to wear masks as well into your workplaces. So what happens if an individual tests positive? The ETS has specific requirements of what an employer must do now in the event that an employee tests positive. They must promptly notify you of the positive test result, and you must immediately remove them from the workplace, and you may not allow them to return to the workplace until they have a negative test result or they meet the return to work criteria in the isolation guidance, or they get a recommendation to return to work from their doctor. But you may not allow them to return to work until they meet one of those criteria. The CDC's isolation guidance says that individuals who have tested positive for COVID and have symptoms must stay home and for 10 days after the first appearance of symptoms. And they must be 24 hours with no fever, without the use of fever-reducing medications, and other symptoms are improving. They are quick to point out that loss of taste and smell is not a symptom to worry about. And if someone never had symptoms, then it's 10 days have passed since the test result. Employers are also required to provide employees with specific information. You have to let them know your policy, and you must provide them a copy of key things to know about COVID-19 vaccines, which is available on the CDC's website. The link is there. You can put that link right in your policy and have people view it directly from the CDC's website. You also need to warn them about the criminal penalties associated with knowingly supplying false statements, and inform them that you won't discharge or discriminate against any individual for reporting a workplace injury or complaints of safety issues in the workplace.
So you also need to, well, as far as the policies go, OSHA does have some sample materials depending on which way you go, whether it's a vaccine and testing and masking, or whether it's a mandatory vaccine policy. So they have policy templates that a number of our clients are using, and you can use that as a sort of a starting point, and then get help when it comes to making certain calls under that policy. But so OSHA does have some, at least they're providing some supporting materials for everyone to get started with, so that people aren't on December 5th scrambling to try to get some things together. So as far as reporting, normally we would have to report any sort of work-related fatality within 8 hours, and a hospitalization within 24 hours, a work-related hospitalization within 24 hours. So this reporting requirement is really incorporated into the ETS. You have to be very careful, though, about reporting and also recording work-related COVID fatalities and work-related COVID hospitalizations on your OSHA logs. I mean, you only need to report or record if they're work-related. Well, there are some, a lot of, it could be a lot of issues with how do you determine if a COVID fatality or hospitalization is work-related. So OSHA has provided some guidance on that, but a lot of employers have need some help on this issue, and we're constantly discussing this type of issue with our clients. So you have to actually go through an analysis of each one of these each one of these COVID-related fatalities, and hospitalizations to see if they're actually work-related or not. So OSHA is telling us the types of questions we should be looking at and asking, and keeping a record of our, what type, extent, and duration did they have as far as the contact of other people, other coworkers at the work environment. Were they working in a crowded work environment? Did they have constant access to the public? Were they working in a public-facing position? What types of physical barriers, physical distancing was in place to minimize their exposure to others in the workplace? Was it indoor? Was it outdoor? Was it a combination of both indoor and outdoor work? Did they have, what type of work-related contact did they have with others who were COVID positive? Was it 5 people in one, work area, one small work area, and did they all end up getting COVID? And there was really no other reason or no other contact between those individuals, or even outside the workplace. So what types of contacts did they have outside the workplace? What were their living arrangements? What types of events did they go to? Some of your employees will tell you they went to a big family gathering or a wedding and came back and will tell you that their whole family ended up contracting COVID. So that's the type of analysis that you need to go through when you're determining whether or not to report this to OSHA or to put it on your record keeping logs. Another record keeping requirement. This one is a little bit unusual because we've never had to do this before. So an employer under the ETS must maintain a record of each employee's vaccination status and must preserve the proof of vaccination, and this includes who's partially and fully vaccinated in your workplace. So you have to retain those records that are also confidential medical records, like the testing records that we discussed, but you have to keep a roster of who's vaccinated, who's fully vaccinated, who's partially vaccinated, and you have to maintain those. Again, so you can't have this roster that's posted up on the bulletin board, or if it's online, accessible to everyone in the workplace because it's confidential. But you do have to retain that roster because, as we'll see, I think on the next slide, you're going to have to produce that. So if in fact OSHA shows up at your workplace, they will ask for, and they can get that roster by the end of the next business day. Not only that, but you as an employer actually have to take that roster and keep a record of the aggregate number of employees at your workplace and how many of those employees are vaccinated. So you actually have to keep a ratio or a percentage of your vaccinated workforce, because if OSHA inspects your workplace and they ask for that, you have to produce that to OSHA within 4 hours, just like you have to produce your normally kept OSHA logs, your OSHA 300 logs, in 4 hours when they request it. So you have to have that information at your fingertips, and others in the workforce, including a union representative, can ask for that same information, that same aggregate information, the same ratio and percentage of vaccinated workers, and you have to produce that to them by the next business day. You also, of course, would have to produce the individual workers' vaccine documentation to that worker. It's their own medical record, and also to that employee's representative. And so you have to produce that by the next business day. So some very unusual record keeping requirements, and not only record keeping requirements, but you have to have those at your fingertips so you can produce those to OSHA very quickly. So, so this is our last slide, sort of, unless people have questions, we're sort of leaving you on a negative note, and that is there's some teeth in this ETS. So if you don't comply with those record keeping requirements, if you don't have a policy, if somehow you're just said, you just say, well, I'm not complying with this ETS, refusing to comply, I'm refusing to do the testing, refusing to enforce those requirements or require people to be tested, then, OSHA can come after you. It's going to be a serious violation. It's over, $13,000, near $14,000 per violation. And if it's willful, about these requirements, you're just choosing not to abide by them. Those are some very, very hefty fines, north of $136,000 per violation, or heaven forbid you violated it and then there's a repeat violation, same story. And there's certainly rumblings out there about additional penalties or higher penalties depending on what happens in the next few weeks with some legislation that's pending in Congress. So so there's some teeth to this. So you're going to have to make a decision about which direction you're going: mandatory vaccination or the vaccination with a testing and masking option. And you really need to be working on getting your paperwork and your policies and your communication pieces together right now, but still keeping an eye on where we're headed with this litigation. I mean, there could be a possibility of a national stay for the ETS even within the next couple weeks. Ultimately, the U.S. Supreme Court might jump in and make a decision, or may not. It's going to be their call to make. So we're going to keep people informed on that, keep an eye on that, but at the same time, make sure you understand what this ETS is, what it entails, and the and make sure you're ready to jump into action depending on what court ends up deciding this. We haven't seen anything yet, have we? I haven't seen anything. So maybe by tomorrow, I think, by tomorrow, I think we'll know, what court has it. So we certainly appreciate everyone's attendance. We'll take a few questions, throw in the chat box if you have them. If not, just send your questions in and Megan will send them to us, and we will do our best to get those answers out to you. So good luck, and thank you so much for attending.
Okay, I'm not seeing any questions being posted right now. We can wait a little bit to make sure somebody might be typing right now. But otherwise, I will send out this presentation along with their contact information either today or tomorrow.
Thanks, Megan.
Yeah, you guys have a great rest of your day. Thanks, everyone.
Thank you.